How to participate in the permitting process. The Texas Commission on Environmental Quality strives to protect the public health and natural resources of the state of Texas. To help accomplish this mission, TCEQ is committed to ensuring meaningful public participation in the decision-making process, including providing for alternative language accommodation. For a list of available alternative language accommodations, see the description below. As TCEQ reviews applications for different types of environmental permits, including air permits, water quality permits, and waste permits, the public has several options to participate in the review process for those permits that are subject to public participation requirements. Administrative review of permit applications. When TCEQ receives a permit application, an administrative review is conducted. Once the application is determined to be administratively complete, the agency issues a Notice of Receipt of Application and Intent to Obtain Permit, or NORI. The NORI is a public notice that includes all the information for public participation pertaining to the application. The applicant is required to publish the NORI in a newspaper within 30 days after TCEQ declares the application administratively complete. The NORI is also posted on TCEQ's website and may be mailed to individuals on the mailing list. Links are in the description. In some cases, TCEQ will also mail the NORI to certain applicants who must post signs around the property with information about the application. Responding to the public notice. All NORIs contain instructions for public participation options, including submitting comments, getting placed on a mailing list, requesting a public meeting, and requesting a contested case hearing. These options are general requirements. However, certain types of applications, including the largest number of air applications, may have additional requirements. These comments or requests can be submitted to TCEQ in any of the following ways. Submit a comment online. Submit a comment by U.S. mail. Submit a comment in person or by courier. Submit a comment by fax. TCEQ is required to review and reply to timely filed comments in a formal response to comments before taking further action on a permit. Some permits require that public comments and requests must be submitted within 30 days after the publication of the public notice or the public comment period. Getting placed on a mailing list. If you submit a comment, request a public meeting, or request a contested case hearing regarding a specific permit application, TCEQ will automatically add you to the mailing list for that application. You may also request to be on either of these two kinds of mailing lists: the permanent mailing list for a specific applicant name and permit number, the permanent mailing list for a specific county. To get on either of these additional mailing lists, you must send a request to the Chief Clerk. Requesting a public meeting. Public meetings enable the public to learn about the application, ask questions of the applicant and TCEQ, and offer formal comments. No decision to approve or deny an application is made at a public meeting. TCEQ will hold a public meeting if there is significant interest in an application, if a legislator from the area of the proposed project requests one, or a meeting is otherwise required by law. A request for a public meeting must be submitted to the Chief Clerk during the public comment period following the NORI and/or NAPD, and must specify that it is a request for a public meeting. Note that a request for a public hearing will be considered a request for a contested case hearing and not a request for a public meeting. Technical review of permit applications. After an application is administratively complete, the ED's staff reviews the application to determine whether it satisfies state and federal regulatory requirements. This process is called the technical review. If the application meets all the requirements, the ED issues a preliminary decision and a draft permit in a second notice, called the Notice of Application and Preliminary Decision, or NAPD, which is mailed to the mailing list, published in a newspaper, and posted on the Commission's website. Except for certain air applications, the public comment period ends no earlier than 30 days from the last publication date of the NAPD. Please note, certain permits are eligible for a consolidated administrative and technical review, as well as a consolidated notice. If TCEQ receives no timely requests for a hearing on an application and it meets all the applicable requirements, the Executive Director may issue the permit. Request a contested case hearing. A contested case hearing is a legal proceeding similar to a civil trial in a state district court. Hearings are conducted by the State Office of Administrative Hearings, or SOA. Requests for contested case hearings must be in writing and include the requester's name, address, and daytime telephone number, the permit number and applicant's name, a statement clearly requesting a contested case hearing, the location of the requester's home, business, or property that is affected, and its distance from the proposed facility, a detailed explanation of how the requester would be adversely affected by the proposed facility or activity in a manner not common to the general public, a list of all the relevant and material disputed issues of fact or questions of fact and law that were raised in comments by the person making the hearing request during the public comment period and that are the basis of the hearing request. Protesting the executive director's decision. Once the decision has been released by the executive director, in many cases there are still 3 possible ways to contest it. Request a contested case hearing, request for reconsideration, motion to overturn, motion for rehearing. If comments were filed during the comment period, there is an opportunity to request a contested case hearing. The agency must receive the request for a hearing within 30 days of the date of the decision letter, which is mailed out by the chief clerk. In addition, after the decision letter has been mailed, any person may file a request for reconsideration, which asks the commissioners to reconsider the executive director's decision. The request for reconsideration must be received by the chief clerk no later than 30 days after the date of the decision letter. If no request for a hearing or reconsideration is received and the ED issues the permit, any person may file a motion to overturn, requesting the commissioners to overturn the executive director's decision. The motion must be filed no later than 23 days after the date that the TCEQ mailed the notice of the signed permit and must explain why the commissioners should review the executive director's decision. If the commissioners have not acted on a motion to overturn within 45 days after the date that the TCEQ mailed the notice of the signed permit, the motion is thereby denied. This motion to overturn is a prerequisite for appealing to the district court. If the commissioners issue a decision that approves a permit application, protestants may submit a motion for rehearing, requesting that the commissioners review their decision. This motion for rehearing is a prerequisite for appealing to the district court and must be submitted within 25 days after the date the decision was issued. If the commissioners do not receive a motion for rehearing, the action of the commissioners will become final within the TCEQ process. For more information, please contact TCEQ staff with the Public Education Program by phone or email. Thank you for watching.